Okay. Okay. The point of having that out there was so that it could show what was on the wall, but it's so bright. Has anybody ever watched any of these things? No. Well, you're saving that as a joy for around about Easter time. Yeah. It just doesn't look at all clear to me. Maybe it'll be clearer on the recording. Just an abundance of light. All right, okay, so anyway, it's recording. So, criminal procedure then, in terms of what we are about. Weirdly, at first glance, this looks a lot thinner. I know not all of you are doing the civil thing, but kind of my mental comparison, I know two of you are. Mental comparison is with civil procedure. Well, this has fewer chapters, a lot fewer chapters in it, and yet it's actually, I think, a little bit longer than the civil procedure. So I don't quite know how that happened. But anyway, there we are. So my basic kind of idea for this is obviously we've got, well, theoretically 2 weekends to work our way through, 9 chapters, because chapter 8 was all about money laundering, and that got picked up in the weekend, or on the Sunday of the last weekend before Christmas. I mean, I'm hoping that was the last weekend before Christmas. You didn't have another weekend on the 22nd, 23rd. I thought that's what she did on the Sunday afternoon. Isn't that what she did on the Sunday afternoon after I left? Well, hopefully not.
Yeah. There's now 2 A-roll study guides. The one that we've done in our office solely criminal practice.
Oh, okay.
Yeah.
Oh, well, it's
16. Who's this Jen?
Yeah,
Oh shit, yeah, you're right.
Okay. So what? All right. So what happened on the Sunday afternoon after I left then? What did she cover then? Yeah, but
Just not the criminal one.
I thought the morning was meant to be like the kind of general thing. Yeah.
Because then you're handed out with what sections, what rules you point to.
Okay. All right. But not. All right. Obviously not the criminal.
It wasn't, yeah, because it was still under.
All right. Well. Okay. Well, all right. Having thrown that into the mix, then yeah. So we've got 9 chapters to think about here, which makes it seem, I think, reasonably manageable. If you look at the official syllabus, certainly the thing I was working off when I sorted out the study guide, almost all of it appears to be about sentencing. Just focus on that and leave the rest of it. But no, I mean, personally, my view is that as far as sentencing is concerned, it tends to be very straightforward. It's just a load of rules like maxima, minima, things like starting points, that type of thing. Yeah. So I think it's, from my perspective, I think it's the sort of thing that's very easy to learn and very boring to teach. So I mean, I'll cover what's in the study guide on sentencing, but from my point of view, yes, all right, you need to know as I say, the kind of like requirements in terms of maximum sentence that the magistrate can impose, that type of thing. What's involved with probation? What is a sentence of no order, or is it a sentence at all? But it's very technical, and it's quite hard to, I think, say anything in terms of the actual sentences themselves that is of any interest, rather than just learning what the rules are. Probably more interesting to understand what the procedure involved in sentencing is. We shall see. So although it looks like it's massively swayed towards sentencing and everything else is kind of in the shadow of that, That's not really replicated as far as the study guide is concerned. The study guide, I think, has a lot of, certainly the first 2 chapters, looking at the composition and jurisdiction of the courts and criminal procedure in all the courts, are fairly chunky chapters. Chapter 3 on bail, maybe not that substantive. Chapter 4, evidence, probably because that's one of my areas of interest, is quite a lengthy chapter. I know that one of the comments that I got from the adjunct that was dealing with the chapter on evidence was that she thought that perhaps, at least at the start, I can't remember exactly how she put it, it was along the lines of she would like to think that people that were studying for the Guernsey Bar had a more advanced level already of understanding of the law of evidence, and that I was, I don't know, approaching it on a kind of noddy basis. So I don't know. Oh, for God's sake, time will tell. So yeah, so the chapter on evidence is a fairly chunky chapter. Juveniles, I feel in terms of the significance of that, and it's like otherworldliness, really. This is an important topic. I think I've put in everything that needs to be in there. Obviously, it's kind of taking us slightly away from the basic kind of court structure, because we've also got to think about the Child, Youth and Community Tribunal. I think that's the right order, is it? CYCT. I think that's it. Yeah, I need to think up a snappy mnemonic that I can use to remember that. But yeah, I'll work on that one. So there's some stuff about the tribunal and the children's convener, because there's obviously an overlap as far as the legal system or criminal justice system is concerned there. Serious fraud, I didn't say too much about that. I think I said everything was necessary. I will just say, for the sake of kind of reassurance about quality control, this study guide has been vetted, each chapter has been vetted by an adjunct. So I've not been just kind of flying my own kite on that, which is what happened with the ethics and the civil procedure. No interaction whatsoever from anybody as far as those were concerned. All I know was eventually there was some feedback as far as ethics was concerned, but not very much. So this is the one of those 3 that's kind of been gone through with a fine-tooth comb. In particular, I think some of the chapters have been gone through with the finest of fine-tooth combs by the relevant adjunct. Having said that, of course, obviously any errors or omissions are entirely attributable to me. I did say to, I think tomorrow we have the pleasure of Catherine Fuchs coming in. And I did say to Catherine the other day that, yeah, if she sees anything or hears me say anything that she thinks is just plain wrong or contestable, she should speak out and not be backwards in coming forwards, and I'm sure she won't be. Don't remember saying that to Mark, but anyway.
That's my people master tomorrow.
Is it? Good stuff. So there was lots of intelligent questions, probing, thoughtful questions. All right. Anyway, so yes, serious fraud investigation. I didn't really have very much to say about that. Obviously, yeah, proceeds of crime and confiscation. Well, confiscation picked up a little bit in sentencing. Mark, hello. Good to see you. Yeah, we're just running through the syllabus. I don't know if you got my message or not. No, I see that you did not. No, I only arrived here about half an hour ago due to technical issues with the aeroplane. So we're not quite as far advanced as I thought we would be by the time we got here. But anyway, so yeah, so we're just kind of scoping out the syllabus and the study guide. Yeah. So yes, as I was saying, confiscation is something that I was asked to pick up in the chapter on sentencing. So there's a little bit in there as far as that's concerned, and I guess it's dealt with or will be dealt with at greater length in Kate's study guide on money laundering. And then international cooperation, separate chapter on that. Again, I think it's right to say that Kate felt that her stuff on money laundering basically replicated the syllabus for international cooperation. Other people weren't quite of the same mind, so we've left that chapter in there. I think it deals with, there's obviously an overlap element in there, but I think it does deal with other separate matters as well. Frankly, if it is replication, fine, that's good, but I think it's covering separate material. I think that's probably all there is to say about it. As far as the chapters are concerned, the only one that I haven't specifically picked up by going through the syllabus is the final one on appeals, which you'd expect to be in there somewhere, and it is. So I think that's it really, just in terms of what we've got to work on. I have tried probably more with this one than with the others to just include some kind of primary source material. So you've got some forms, some bits and pieces of quotes and judgments, much more so than in the other ones. Yeah, and hopefully I haven't checked in the printed copy, but when I was looking online the other day, it looked like all the forms had come through as intended. I know that certainly one or two people expressed the view that parts of the text and the forms seem to have a kind of mobility issue, by which I mean they were mobile when I wanted them to be stationary, and they seem to be kind of shifting around when other people were looking at them and covering up text. So I'm hoping that has been resolved this time. But anyway, if you think that there's text, valuable text covered by forms where I've put them in, or text boxes, then feel free to say so. We'll try and rectify that. But I haven't come across any examples. All right, so my brilliant plan for this afternoon was we'd have got through probably to the end of chapter 2 by the time that Mark arrived, and we then had lots of things that we could do, but yeah, so we have not started. We've got a nice full day awaiting us tomorrow. I don't think there's anything that we can do to avoid that really. But have you guys got any questions? Because I'm kind of conscious of the fact that I've brought you in here for this hour from 4 till 5. Questions or thoughts? Anything that as you've looked through? I know Gemma said that she's been diligent and looked through study guide. So things of substance, things of technical interest that we could at least identify now.
We went through the first 2 chapters.
Right, good. Excellent.
I just really need to make notes.
Mm-hmm.
I don't know if it's maybe useful to go through if there's other cases that we know about, we can sort of put them through, because what I find is quite a lot of them go through the law quite clearly with judgment, so then it helps that understanding. Yeah. So then maybe that's something just more of a go through.
No, well, what I did yesterday was to work through basically trying to pull up all of the cases that I've referred to, and then hopefully I'll save them onto that memory stick that I've got plugged in, so that as well as things like laws and rules, there'll be some cases in there, and that I've highlighted what I think are the relevant passages in each of those cases. And obviously, again, I think as I said last time, some cases are more useful. We just keep coming back to them again and again for different aspects.
You virtually never hear anything cited in your course.
Well, I mean, things like
on sentencing,
yeah,
the court's been quite clear saying, I do not wish to hear reference to any other case unless it's be a guideline case, of which there's really only one that you ever hear referred to.
Okay. All right. I'm hoping that's Richards.
Which is Richards.
He's still repeating. All right, but no, I mean, cases like, I think, Jones from 2016, I think that's quite a case that I would, I'm not saying it's referred to in court a lot, but I think it comes up for a number of different things. And I was going through yesterday and just in terms of the different grounds of appeal against conviction. You had things like having a majority of the jurors, a simple majority. Is that a ground of appeal against conviction?
Definitely not. I mean, that's been, Fred
Well,
Rattray from the law office has got absolutely taken apart, suggesting that it wasn't a good a verdict because it was only, whatever it was, 7-3 rather than 12-0.
Yeah. But no, but I mean, so the Court of Appeals looked extensively at the principles involved in that, and it's brought in things like Snooks against the UK, and looked at simple other tribunals in different jurisdictions like Isle of Man or Scotland, where a simple majority is seen as perfectly adequate and HR compliant, etc. So it's quite interesting from that point of view. I think another one of the grounds of appeal in that one was, which is obviously a kind of more recurrent trope, if you like, in terms of appeals against conviction, was the adequacy of the summing up to the jurats, that type of thing. Need for jurats to, God almighty, jurats to give reasons, or the suggestion they should give reasons for their verdict.
There's an absolute obsession there in the UK with the court cannot give reasons and there shouldn't be any attempt to give reasons. But in other jurisdictions, it would seem outrageous that you could be sent to prison for 20 years and you've no idea why.
Well, yeah, but I mean, obviously, each tribunal is different. But if we thought about, I know you don't have jury trial here, but I mean, a jury convict people, and then the judge passes, and it's different. The judge passes sentence, whereas at least you've got the same individuals making a guilt versus not guilt decision, and then coming on to talk about it. So I know they don't explicitly deliver or articulate the sentence, but there is an articulation there, and you can see how there's a kind of level of consistency there. Whereas, I was talking to my students on the bar course before Christmas about the sentencing process at home, and looking at drafting, I think it was drafting counts on the indictment, actually, where you have a continuing offence. Let's say someone's allegedly stolen rare books from a library. It's been known to happen. And the prosecution have got maybe CCTV, they've got library records, etc., and they can identify when the first offence allegedly occurred. They can identify when the last offence allegedly occurred, and they then charged as a single count on an indictment, stole 35 books on a number of different occasions, probably 35 separate occasions. Here's a start date, there's the end date, and there we are. So at the end of that, there's one count on the indictment, 35 different constituent elements in there. And at the end of that, your tribunal of fact is going to say we find the defendant guilty or not guilty. Yeah. And frankly, when the judge at home then puts their wig aside and scratches their head and thinks, well, wonder what sentence I should impose here. The judge has got no idea whether they all agreed that there was one rare book that was stolen, or 35 rare books that were stolen, or some figure in between, or whether they, some of them thought it was one, some of them thought it was 35, and some of them thought it was like 4 or 10. So at least here, because you've got the same entities involved in the kind of fact finding and then determining what the sentence is, I mean, I think it should be a smoother, more justifiable ride there, really.
I suppose so, except in the UK, you'd have a judge bound by a whole series of sentencing guidelines.
Well, there is that,
as opposed to 10 people, one of whom thinks it's absolutely outrageous. And for example, in the Alderney court last week, a lady, 54, one previous conviction for which she received, one previous conviction in her life, hopeless alcoholic, had gone into a friend's house and had taken some money and had been caught immediately. Probation report says this lady's a hopeless alcoholic and needs to get over her boozing. But if the court were minded to go as far as a community service, she would be suitable for some community service. And Durance went out and came back and said 6 months. Take it down. And you can get extremely erratic sentencing from tribunal that aren't and don't feel themselves bound in quite the same way.
I recently heard a paper a while ago where somebody said something about the prison sentences should be slightly longer so that people can have better drugs intervention, alcohol prevention program. And might that be one of the reasons why it's prison?
The answer is it could be, but you see all the, not really I suppose for this course, but you see all the criminology studies that say there's just no point. And the Guernsey court is forever giving people, you get caught drink driving, you might well end up with, and you plead guilty, and you've got no previous convictions at all, you might well go to prison for 6 weeks. You've got excellent litigation. What's the point in sending someone to prison for 6 weeks? Particularly for something like that, where the reason you committed the offence is not, I've carefully thought about it and decided I'm going to drink drive so I don't want to get away with it, but rather I had too much to drink, that's why my judgment was impaired in the first place. But the Guernsey court does love giving people short sentences. And indeed, previous judges have loved giving people a whole series of 7-day sentences on the basis that you can't appeal against them. That used to be very popular. And we're talking about appeals against conviction. I don't know the case of Jones. And those are my two colleagues in the room, so I don't spend as much time in the criminal courts as I used to. But last time I had an appeal against conviction, which was successful about 4 or 5 years ago. When I looked into it, that had been the first successful appeal against conviction for about 20 years. Because simply, not only does nobody get off, unless it's a one-on-one style offence, where the court says, how can I decide one or the other? The conviction rate in Guernsey is astronomically high compared to the UK, and the prosecution will say that's because we adopt a very realistic approach and don't bring cases unless they are really strong cases, because we don't want to do that. And I know that those who defend more regularly than me feel that it's because there's never been any case where the police officers haven't been automatically believed, or the customs officers.
Okay. So we're still in the Lord Denning era, where it'd be unthinkable that a police officer should perjure themselves. Disgraceful allegation be made by defence counsel.
I think it must be taken into account in sentencing. You should have impugned the reputation of this officer. And these things you're going to, those of you who pass the bar exams and practice in the criminal courts are going to have to contend with. I wonder, just one or two thoughts occurred to me, simply because they've been coming up in the court recently. And as we know, stuff that have come up in the court recently might well be exam material.
Yes.
One was, we had a case of abusive process, and I couldn't actually find one that had happened before, but the judge said, I just delivered another judgment last week on it. So obviously, for some reason, it's becoming more popular here. And obviously, both of them failed hopelessly. But there was one, the one I did is embargoed until the trial is over, because it wasn't successful. But there must be at least another one out there, the name of which I can't remember now. But you should dig it up and find out, or by the time the bar exams come along, the one that's embargoed, which I can't tell you about, will be out. But I thought that might be an area to become familiar with, because actually there's quite a lot of authority on it, and certainly when it comes to applications to exclude evidence, we should all be under section 78 of our PACE law. The judge keeps coming back to the judges to say, yes, Mr. Dunster, but look what happened. What did the court say in the Jersey case of Law Officer Crown and Warren? Mr. Warren was a big-time drug dealer in Jersey, but then the Jersey police had taken advice from one of the Jersey law officers, who said, sort of, you shouldn't really do this, but you'll probably get away with it because it's the Channel. I'm guessing he's thinking because it's the Channel Islands and the prosecution will get away with it.
I'm not sure he quite puts it in that way.
I can't remember, but in any event, whatever they said, the Jersey police went well beyond anything he could have possibly suggested, and got so far as to lying to the Jersey, French
French
authorities.
authorities, yeah. They put I think, a bugging device on the suspect's car.
And that went all the way up to the Privy Council. Anyway, the police have behaved as badly as you could imagine, not only stretching the rules, but actively lying to foreign law enforcement. And there, the Privy Council agreed with the original trial judge and said, this is absolutely outrageous, we cannot possibly condone this. However, we're going to admit all of the evidence. And what I've found, certainly in the Guernsey courts, is whatever submission you start with making is, yes, Mr. Husband, but in Warren, and the supposition is, it doesn't really matter how, or you're going to have to be more awful than anyone could imagine, than the police lying and breaking all the rules, and it's still going to come in, which I think is relevant when you're advising your clients. I think we should try and exclude this with evidence. Look what it says, it's available. The practice is it's almost never excluded.
Yeah.
And I thought that might be a practical point. Because I know, having seen other things, people get very excited about I can apply to exclude this evidence. Yes, you can apply. No, you shouldn't build your whole case strategy on an application succeeding.
What's plan B?
So there was, firstly, it was about abuse of process argument. Secondly, Warren, this case of Warren, the Privy Council from Jersey, therefore not binding but extremely persuasive on us, seems to be quoted quite a lot.
Yeah, we use it on the bar course at home. So.
Oh, right, it's made it across the board. The other one I was looking at the other day, and there'll be another one coming out in a case called Law Officers against what D1, Mr. Dawson Ball, D2, Miss McPain, was one I'm sure you're familiar with. There was two judgments from the Royal Courts on a case called De Coke.
Oh, yes.
That was really, really useful. Coke was a sort of South African C-O-C-K, something like that. And that had a lot to say about the admissibility of evidence, because various things are being challenged as being hearsay or otherwise inadmissible.
Because he was an employee of the bank, wasn't he? He'd been interviewed by, I think, someone from HR and a superior manager, etc. But there was a question about whether they were investigators, whether he should have been cautioned, and that. So whether the contents of those interviews would be admissible in criminal prosecution.
And yes, and there was some other stuff about when, because what had happened, Mr. De Coke worked at the bank, and for reasons that I'm not sure I worked exactly right, circumstances arose where a potential customer of the bank who wanted a big loan, I think either had been declined elsewhere or there was a question mark about whether he would meet the lending criteria, gave Mr. De Coke a bright yellow E-type Jack, which he then drove into the bank car park. And it makes you, I mean, it's almost, you can't possibly be guilty.
Completely honest.
It happens, doesn't it? I mean, it happens all the time, and I'm sure our respective practices that you're given a Jack. But there were other things where I suppose what would have been the co-accused, but had it on his toes, was recorded on the bank's recorded phone lines, making certain statements, which were incriminatory in some way or another. But the statement was being introduced for the truth of its contents by someone who was not going to be present at court. And again, there was some interesting discussion in this case about De Coke, about not only the side Roberts just mentioned, but this side as well. And I thought, on reading that, that's a really interesting judgment, because it covered a lot of the usual everyday hearsay problems that you do come across in the criminal courts. And you have to be ready to deal with them like that. There's no, right, I think we better step back and have a careful analysis. Often it's just, hang on, stop, I don't like what I've just heard, or I don't like what I think you're about to just say. So that seemed to me to be another good one to be familiar with. And there's going to be another analysis of that coming up to some degree in this case of Dawson Ball and McPain as two defendants sometime in the next 3 or 4 weeks, and because it's going to be dead current, it might appear in the exam. And that one will also look at the international cooperation law, the 2001, 2003
in terms of obtaining evidence.
Yes.
Yeah. I can't remember off the top of my head.
That again seems to be becoming quite common because it's now available. And maybe because people are becoming more used to the law officers, they're reaching out to get information. And here we had a case, we're applying to exclude some evidence, and we had a case where the Guernsey authorities had asked the French authorities to put a phone tap on a particular line. And they did that, and then they sent across the transcripts. And then there are some voices saying things which may or may not be the defendants, saying things which may or may not be indicative of guilt. But when you look at that law, it's rather difficultly worded. And it appears to say, look, this evidence will be admissible despite the fact the person's not there. Subject, sort of, and you think, well, that should be a full stop. But it isn't. It says, subject to the court having the power to exclude on looking at the following two factors. And one of them is the person giving the evidence going to be present? The second one is, did the person have a right to be represented? Now, I can see this one going on up because it seems to me that's a bit of a mess, because the second one is, did the person have a right to be represented? Well, obviously, if you've got covert surveillance tapping the phone, you're not going to have a right to be represented. Can I please make representations about the covert surveillance of me on this phone line? And everybody has a right to be represented in Guernsey when you're charged with things. So, not quite sure what that means. And will the person be produced? Well, actually, no. The person, there were two people in a phone call, say, the person who was sat in France, they're not going to be produced. They may not even know who they are. And the other person may well be the defendant in this case. And the answer is, well, your client will be produced, says the judge. Yeah, but Judge, are you saying that he has to give evidence? Because that doesn't sound right, that you're saying, well, he has the right to give evidence in his own defence. He does, but you're saying now you're going to omit the evidence because he's got an obligation to be present. And it seems to me that might be
Well, that sounds fascinating. I mean, off the top of my head, it sounds like it's absolutely not what that process was designed for. It's designed for much more formalised obtaining of evidence.
Yeah, kind of please get your statements from.
Yeah. Or alternatively, in a quasi-judicial setting. So I'd be, well, I mean, regularly surprised about things, but I'd be surprised if it was thought that it extended or extended easily to a situation of covert recording.
Yeah, I mean, there's always been that oddity, hasn't there, which always struck me as odd, that as a matter of English law and as a matter of Guernsey law, you can tap someone's phone, say, but that evidence is not admissible against them. And that's always struck me as the oddity. It's like, well, why not? Why not just draft the law and make it admissible? But the English law has set its face against such sneaky and underhand behaviour by the law enforcement authorities. But why is the first oddity. But the second oddity of our law is the court said, well, actually, no, as a matter of English law, it's an outrage and admissible that you should be able to tap someone's phone and use that evidence against them. However, if it's being done in Holland, and there seems to be a lot of drug and people smuggling cases coming out of Holland, then it is admissible in England. In the way that if the very same people who are having their phones tapped in Holland were having them tapped in Harwich, or I don't know, wherever the port that goes to Holland is, it wouldn't be admissible. I never quite understood the logic of that.
Well, I mean,
make it all admissible or make it all admissible, but don't end up.
Well, I think it's probably on the basis that the court doesn't want to countenance let's say, the UK authorities behaving in that sort of fashion. So then, it's kind of like the end does not justify the means. Whereas if this is all going on somewhere else where our writ does not run, and you've already got the product available, it'd be a shame not to use it, wouldn't it? I think that
sounds right, doesn't it? It seems a bit intellectually odd to not be all in or all out.
Well, I think if I was really kind of put my evidence hat on. I think there's an old case from, I don't know, something like the 1950s called King and Karuba, which basically talks about an English case that talks about if the evidence exists, then even if it was obtained illegally,
The fruit of the poison tree, isn't it?
yeah, we don't have that. That's American. Miranda.
And it's odd how countries with, you think, well, you're a westernized democracy with a legal system we think we recognise, could have come to such very different views on things.
Well, they can be, on the one hand, they can be very principled, and then they can be extremely pragmatic as well. There's no great rhyme or reason to which way they're going to jump.
The only other thing that occurred to me, because it took me so long to get my head around it, was the drug trafficking confiscation process. Because you all start, and I guess most people in this room are commercial or civil practitioners generally, from the fact that the idea is what the law is seeking to do is to put you back in the kind of the position you ought to have been in.
Impoverished.
But intellectually satisfied. But imagine you have the classic case of, you've got Mr. Big in England who has £100,000 worth of drugs, and he gives it to his minion, who gives it to almost invariably a hopeless individual who is indebted for drug money or otherwise under the control of Mr. Big, who says, here's 500 quid and a ferry ticket. Go over to Guernsey, where you'll be met off the ferry, which is, don't worry, it's no trouble, it's just like the Isle of Wight, there's no customs. You'll be met off the boat by another minion who takes the £100,000 worth of drugs and gives it to Guernsey's Mr. Big for onward distribution. And the courier gets nabbed, and often the other people in the chain are not got, because the courier won't speak, and I do want to talk about that in a minute. And the courier ends up having to plead guilty because they've got it in their car, or they've got it inside themselves, or whatever it might be, they've got no choice. And then you have the drug trafficking confiscation report, and it says, well, what's your benefit of your drug trafficking? And you might think, well, the benefit for me was 500 quid. But actually the law says, no, the benefit for you was the £100,000 of drugs that you had. Even more
street value.
The street value. And you say, but hang on a minute, I only got 500 quid for it. That was all I was ever going to get. No. Your benefit is £100,000, and it becomes even more stark if they nick, the Mr. Big at either end, and all three of them are in the dock in Guernsey, and all three of them are said to have benefited to the tune of £100,000. But there was only ever one lot of drugs valued at 100. How can we all benefit? And it did take me a while to sort of get my head around it, and the factual permutation is going to become more complicated. To ultimately come to the conclusion, you've got to put aside your sort of civil litigation side and think this isn't designed to say you actually benefited. It's a poor choice of language. It's just a further punishment to mess up your life by saying that you benefited to the tune of £100,000 by couriering across the channel, or even perhaps handling for a fairly short period of time that money. And you can get confiscation orders for 3 lots of £100,000. Now they would look at the second figure, how much is actually realisable from you. And if you're hopeless and you've got no money and then 500 quid and spend 100 quid of it on the fruit machine on the ferry, it'll be 400 quid. But if you had other money, you can find more money than the original value of drugs being extracted from everyone.
Yeah, because presumably there's nothing in theory to stop them claiming the £100,000 against 3 people and getting it.
Correct.
Yeah.
And that can and does happen. Not as often as it might do, because often the only person being caught is the hopeless individual, rather than the Mr. Big. The one thing I don't know if it's covered in the notes is when you're representing someone in a criminal, it's obvious to you, of course, but when you're representing someone in a criminal case, lots of intellectual energy is expended on admissibility points and appeal and all the rest of it. but actually, right from the word go, you know that they are hopelessly guilty and will have no choice but to plead guilty. And what people really want to know is how long. I know, they're thinking, I know I'm bound to rights, you know I'm bound to rights. What I really want to know is how long. And that's often very difficult for the reasons why we came in, because in a drug sentencing case, you can say, well, how many X quantity of drugs equals Y years of sentence? And for a drink drive case, you can say you've got the case of, come on, you've read them. What's the precedent case for drink driving?
It's an H.
Hatwell or Hartwell or Hatwell, I think. And that if you cross a certain breath reading, then you're going to go to prison. And if it's a second offence, then the breath reading is lower still and you're going to prison. But other than that, it can be very difficult. But the one thing you can do, and it's not, I haven't seen it written down anywhere, is you can give assistance to the authorities, and it's worth bearing that in mind. And if you've been arrested for drink driving, you can't give assistance to the authorities. I'll grass up the barman who served me that last pint. It will not help you. But in practice, it's big decisions for your clients, because if you're called down to the customs shed the day after you get called to represent someone who's charged with drug smuggling, and they might be facing 5-10 years in prison, there's only two things they can really do to help themselves. One is to plead guilty at the earliest opportunity, and two is to give assistance. And that's not necessarily, from my review, the notes as obvious as it might be, but in practice it's very important. And the amount of assistance you can get could be, you can get maybe a third off for pleading guilty, but you could get a third off or possibly even more for giving assistance. And how much you get off depends on the quality of the assistance you give and the reality, which is how much danger are you putting yourselves in. And there's plenty of authority for that, most recently in the Court of Appeal in the Law Officers of Crown and Fowler, where they re-emphasise that it is in the public interest that criminals should be encouraged to give evidence against each other, because it's in the interests and ease of law enforcement, which is in the interests of all of us, law-abiding citizens. And the way that's often done is you can just speak up in the interview and say, yes, it was Smith. If you're quick, he's probably outside now. If you want to do it more subtly, then you'll have the officers doing the investigation. And then there is an intelligence branch who are separate from them, who would gather intelligence from your client outside of the realm of the case. And that's particularly if your client wants to give information confidentially. And if that happens, there will be a letter produced, kept in safe in the law officers, that's produced to the trial court at the end saying, Mr. Bloggs gave assistance that was of low, medium or high quality, and we think he has or has not put himself in danger, those sorts of things. Of course, the biggest thing you can do is to say, I will give evidence. It was Mr. Big is Fred Smith, and I'm going to give evidence against Fred Smith. And if they can catch Fred Smith and you give evidence, it can make a massive difference, a difference of years and years to what you'll spend in prison. And it's a difficult decision for your clients, but it's often the only way they can meaningfully reduce their sentence. And some of the people that have here have been extremely nasty individuals. I had one years and years ago now, where I didn't really think it existed, but they did produce witnesses. He was the Mr. Big in England. He was a proper machine gun toting yardie boss, and they extradited him, or not extradition is the right word, but under the Indictable Offences Act 18 something or other, which enables practically a free transfer of indicted prisoners between the UK and Guernsey. Brought him here and brought various couriers out of the witness protection programme and produced them in what I think was the last contested committal in Guernsey, to point the finger at him and say it was him. We're not talking a doc ID here, but in terms. and they had got effectively a new life because they were giving evidence against them. Anyway, I'm sure that's a long way away, which brings me perhaps to the final point I wanted to make, which is when I was bâtonnier, the issues which used to come up at the disciplinary level, which worried me the most, were not the, oh, my advocate didn't answer my correspondence type stuff, but was the concern that no advocate should take on a case which they don't have the time, skill and experience to do. And that is not a problem in heavy civil litigation by and large, because that's well catered for. The thing that used to worry me was you are the duty advocate, you may have only been called less than a year, you go down to the police station, someone is charged with something very serious. And that's fine, you can go through and do the police station side of things, but that does not mean that you are equipped to do the roll call criminal trial later on, something where someone may be on trial for facing huge sentences in prison. Circumstance, I'm a bit behind the times, by which I mean 25 years behind the times, probably in England. But I imagine in England, if some of these people were being defended in England, it would be, well, you'd have a QC and a junior barrister and maybe one or two solicitors. Whereas we know the reality here of legal aid is it would be often someone extremely junior who'd be told you can have no assistance, you've got to do it all yourself. No, you're not allowed to charge for research, you're not allowed to charge for this, you're not allowed to charge for that. And it's always been a worry, not now, so I'm not bâtonnier, but when I was, that if something's going to go badly wrong for the Guernsey Borough as a whole, it's not going to be in heavy civil litigation, it's going to be someone who was represented by someone who was lacking appropriate experience and went down for years and years when perhaps they ought not to have done. And it seems some of our colleagues, you have to have a degree of introspection, don't you, to say, I'm out of my depth here, and it's a great failing amongst all of us lawyers in the room that we all have a very high opinion of our own abilities, and sometimes we need to take a step back and say, perhaps I ought to have my hand held on this one.
Yeah, I mean, it's that my lack of familiarity with the way that firms work, coming from the background of the bar. I mean, presumably you could have somebody holding your hand within your firm.
You could do, and you should do, and I would hope that you will.
And it shouldn't be seen as a sign of weakness to go to somebody and make a request like that.
Absolutely not. And if you're in a firm though where and this is the difficulty, some people are in very small firms, and so if your colleague is away, well, I'm a matrimonial practitioner, what the hell do I know? Or I'm too busy, I can't do it, or I'm on maternity leave, or whatever, for some reason that someone isn't there. If you phone up one of the other firms, particularly in the criminal side of things, where you don't have to say, I can't speak to you because I might be conflicted out of acting for Megabank PLC, you will find people willing to help. And I've certainly had that happen when previously people have phoned me up, and I was grateful for the assistance of my colleagues, especially when I was just starting, that people were willing to do that, because it's in none of our interest that there is an almighty muck up. It's not in the bar's interest, and it sure as heck ain't in the accused interest if something should have gone wrong.
No.
And nor would I think it all honestly the accused be upset if you said, do you know, I think someone with more experience needs to handle this case. I think they're likely to go, thank you for your honesty.
Yeah, absolutely. Yeah. I mean, certainly in England and Wales, the BSB handbook would effectively preclude that situation from arising in almost every case, because whilst you could happily accept instructions to attend a client at the police station and maybe sit in on the interview with them and advise them whether to answer questions or not, there's a very strict rule, which is obviously applicable for the bar rather than for solicitors, but that you should not be witness and advocate. You shouldn't put yourself in a position where you could be witness and advocate in the same proceedings. And obviously, in a criminal case, if your client has made various incriminating admissions down at the police station whilst you've been in attendance with them, and they would have pleaded not guilty at the trial, there's an issue there. Or if they've said nothing and people want to draw adverse inferences against them. And they say, well, I only remained silent because my brief told me to make no comment. And then you end up having to give it evidence as to the advice and the disclosure from the police.
That's never happened here. And I think that's principally because it hasn't happened, but it might do. But secondly, we have the absolute right to silence still. We have the old style caution. We have the right, must caution you.
Of course, you don't have adverse inferences.
You have the, at least if I get it right, you do not have to say anything, but anything you say may be taken down and used as evidence against you, rather than, yeah, you do not have to say anything, but I have to warn you that if you fail to mention something now which you later rely on in court, it may be used against you, you have the right to remain silent or something like that.
Yes, yeah.
So we don't have that particular problem, which I've only read about in England. We do have the problem where people turn around and do say, my advocate told me, I begged my, Julia and I have heard this within the last month, I begged my advocate to speak. I begged him, but he refused to let me speak. That doesn't sound very likely that it should have been exactly like that. I imagine it was, you're absolutely your choice, but here's the advantages of speaking, here's the advantages of not speaking, and consequently the disadvantages of both. But I've slightly lost where my train of thought was on that.
Well, you're saying it's not a situation that really arises.
Yeah, because of that influence. And then because if people have given evidence in an interview, answer questions, well, it is what it is. And you can hardly go, well, I should have been told otherwise. You go, well, all you're doing is telling the truth, surely. And if they haven't answered any questions, you can say, well, we'll speak from the witness box in due course. Which reminds me of another point, which I'm not sure is sort of covered in the notes, which is you get down to the station. What do you advise people? And it's not always obvious because you go in there, and you go up to the desk custody officer. The first thing you should ask for is some form of advance disclosure. You may or may not get it. It may or may not be available. It depends. And it depends on the nature of the offence, where they are in the investigation of the offence, and the particular officers involved. If you call down to one of the hopeless drunks of town who's been accused of nicking a bottle of whiskey from the co-op at the end of the market, you're not going to get any advance disclosure. It's there. They just want to get it over and done with the interview. But the officer may say, well, he's been accused of stealing a thing, and we've got the CCTV watching it. You may get no more than that. If it's a second interview after someone's been in custody for 3 days already for some horribly serious offence, then you would be entitled to more. And I've certainly had robust discussions with the officers saying, well, you're saying you want to get to the bottom of it. I'm saying we'd like to get to the bottom of it, but I can't advise my client until you tell me more about what the hell this is all about. Well, we'll find out in the interview. Well, that's not good enough. I can't properly advise him, and unless I can advise him, I'm just going to tell him to say nothing. And therefore, your wish to get to the bottom of it can't be a genuine one, otherwise you would at least give us some idea about what's going on. And you may have to have a robust discussion in a very hostile environment, because none of the police officers are going to beat you up. But there's a lot of passive, the advocates are not popular when you're down there defending someone who the police probably think did it. Otherwise, they wouldn't have arrested them. But you have to be clear that your job is to stand up for the person who often is extremely frightened themselves, may not be familiar with what's going on, may not be intellectually at the top of the heap. And it's your job to stand up for them. But you try and find out what you can, and then you have to go and speak to them. And the first thing I'd want to find out from the police is this person the sort of person who I do not want to be, because you will be, locked in a cell with? That if they are violent or mentally disordered or both, and they're in an extremely stressful situation, and in you pop giving bad news, it can be difficult. Yeah. So I certainly have.
Depends how big the cell is.
Well, the cells are pretty small, and they've got a sort of, there is someone there, and you need to be realistic about your own security as well. By and large, it doesn't arise on the island. By and large, it's okay, but there will be occasions. But when you go in, the question is, you're going to say, look, you're at a crossroads now. The police are going to interview you. You can't stop that. And your choice is really, you've got three choices. One is you answer all of their questions. And if the whole thing was nothing to do with you, that is undoubtedly the best thing to do, because you will clear it up as soon as possible. Or if you have a rock solid answer which will not change as to what was going on, which will not change between now and the cross-examination by the prosecution at trial a year down the line maybe, again, you should say now, because we can then sing from the rafters, my client's version has not changed from the day he was arrested till now. And the reason it hasn't changed is because he's telling the truth. You should answer the questions. The option one. Option two, you could say nothing and take your right to silence, and you will trot out that no adverse inference will be taken or what have you, but you should explain that that is, of course, the theory, not the practice, and probably a great deal of adverse inference will be taken, depending on the circumstances of the case, from the fact you didn't answer, particularly if you later do pop up with an explanation, or you, otherwise the thing really calls for an explanation from you. You were found in the shop with the broken glass shards all over you and the jewellery in your pocket, and yet you're pleading not guilty. You're thinking, well, we ought to hear something as to what your defence is. But say nothing is an option open to you. Third option, which unfortunately comes up in practice, is you can answer their questions until they get a bit difficult, and then you can go no comment. And that is the worst possible of all worlds, because if you answer all the questions, transcript will be produced, and everything you say will be taken down and maybe used evidence against you. If you just go no comment, they probably won't bother producing a transcript. They'll just say there is a no comment interview. If you have the third option of answering the easy questions, but then going no comment when the going gets hard, they certainly will produce a transcript because it looks really, really bad. So actually your advice to your clients should be either answer all their questions or don't answer anything. And it's not easy because you're at the start possibly of a long journey for which you have limited information as to what to do. And most clients do themselves more harm than good by answering questions in an interview, because often they'll say X and then something will come up in an interview. Oh, no, I meant Y. You know, well, were you lying before or were you lying now? It kind of doesn't matter what client is a liar. But it's a difficult decision, and it's one for the client, because only the client really knows by and large what's going on. But if the client doesn't know and you don't know, and the police won't give you a decent amount of disclosure, I think that you're not really in a position to properly advise. And in that circumstance, I might try and push for more disclosure and say, well, hang on, just you won't. All I know is I've been arrested for fraud. Well, what the hell was this all about? And if you just can't get anything, I might say at the start interview, saying, I've advised my client to say nothing. There's been no disclosure. I don't know what's going on. I'm happy to answer questions if there is disclosure, but at this stage, although it's my client's choice completely, and it's his decision, I understand he's going to go there.
And is this in part your whole point about, it maybe depends on who the officers are or what your relationship is with the officers? Is it partly because as a duty advocate you're only down at the police station once in the blue moon, so you never build up any kind of relationship with officers? Because obviously, to a certain extent, if you're a solicitor going to the police station, on a fairly regular basis, possibly because you're a named solicitor, the local criminal fraternity always summons you when they're nicked down at the police station. There may be, you build up a working relationship, don't you? Because there may be, it's not quite you scratch my back, I'll scratch yours, but there are trade-offs that occur, and a modus vivendi evolves whereby perhaps you're more, rather than being a complete stranger that they don't know they've never seen before, there might be more forthcoming. Does that not happen?
There probably is an element of that, but I've never really found that myself.
No.
It's all tended to be the stage of the investigation, the complexity of the investigation, how much pressure there may be from other things. My personal practice is not enough in this area
No.
that I can claim that I'm down on the police station. But I did that for 20 years, and I'm really glad that's run its course. I don't ever want to go out again in the middle of the night unless I absolutely have to. And the models of that is voluntarily run off.
I can see that. Okay, well, I appreciate everything you've said this afternoon, Mark. I see it's now 5:05, which means you're probably expected to go. This lot are all expecting to go now. I was actually intending to ask you a question, but I think I might save it to John and Catherine's. Just about the relationship between the ordinary court and its summary jurisdiction, and the magistrates' court and Sark and Alderley, and how they kind of intertwine, as it were.
So the answer is it doesn't ever come up in practice. Every case is really straightforwardly dealt with. Magistrates' court, disposed of in magistrates' court, and the prosecution elect for committal to the Royal Court, or it's indictable only, or you elect for trial in the Royal Court, and then it goes off to the Royal Court, or it's dealt with in Alderley or Sark. It only comes up is if Alderley or Sark decide they don't have sufficient sentencing powers to deal with it, and they send it to the ordinary court, where it rests for 30 seconds before being sent to the magistrates' court, where it may stay, or it may be sent up to the Royal Court. But the magistrate, you can get 2 years for one offence and 3 years for one more. So you can get a lot. You can be in for a 2-minute hearing. I exaggerate. You can be in for a very short hearing in the magistrate court and get sent down for years. That the only time the ordinary court comes up in practice is if you're appealing against the decision of either appeal against sentence or appeal against conviction.
That's interesting. Okay, thank you. Right, okay. Shall we let Mr. Dunster leave? Yes? Okay. I think we've got the power to compel you to stay.
Well, I may see some of you, I think, at the one more weekend.
Yeah, 19th, 20th, so 2 weeks' time.
I'm not sure I'm down at the NLS study weekend.
Oh, there's a revision weekend, yes. Sometime in April.
Because I think you will have read the notes, and you will be, by the time you've done the bar exams, more on top than you will ever be for the rest of your life on what the appeal period to appeal from a criminal conviction in the Sark court is, and all this sort of thing. But if there's that's part of the exam, but the real heart of the exam, because it's a practice exam, is going to be, because if you pass this, you could be in the courts the next day defending someone who could go to prison with all the consequences of they lose their job, and then they might lose their house, and then even when they come out, they've got nowhere to live. And if you've got nowhere to live coming out of prison, that's a really high risk of recidivism and all the rest of it. So this is the #1 paper to show that you're safe to be let loose on. So I'm happy to come along and talk a bit more about practice, because there's a lot of difficult decisions. The obvious big decision in most criminal cases is, what do I plead? And if I'm pleading not guilty, do I give evidence or not? And that is a massive decision, because it depends on the nature of the case, it depends on the nature of the client, it depends on the experience of the client in the criminal process, it depends on the likely line of cross-examination and how the client's going to react. And it's a very difficult decision, and one that probably more than any other affects the ultimate outcome of the matter. So before Catherine Biggs, who's an extremely experienced practitioner, coming tomorrow, can talk about how she advises people in those circumstances.
Okay, excellent. Well, thank you very much.
Good luck to all of you.
Thanks, Mark.
Okay. Enjoy the rest of your trip. Yes, we'll try to get off the island.